Live from Chattanooga, Tennessee, it's Nooganomics with David Tulis.
Thanks for giving us a couple of minutes of your time at AM 1240 Hot News Talk Radio, the station in which you report and the world decides, the very attentive, media-oriented platform that includes Nooganomics.com, Nooganomics being the sponsor of our show. And we argue that you should love your neighbor and buy local. And we philosophize and muse on points such as this one, that near is better than far, and that small is better than big, and simple than complex. And down in the footnotes, in the small type where the fleas fight with scimitar and javelin, we've got personal is better than corporate, and physical than abstract. We are trying to be localists. We're trying to be provincialists. We're trying to be liberal, classical liberals here at AM 1240 Hot News Talk Radio, which means we believe in the marketplace and have appreciation of the democratic processes of our founding. And want you to know that there's a great lunch awaiting you at Ari's Restaurants on the lake. Ari's Harbor Lights at 9700 Hickson Pike. It's by the marina. You just drive north on the Pike. And there's a dinner for two for $19.95, and you have 10 entrees to choose from every evening. Try that if you want to do an evening visit to Ari's Restaurant. And 3 to 7 happy hour. The number is 843-2800, 843-2800. Ari's Harbor Lights, great restaurant, loco-centric to the core. You will enjoy eating there very much. We're brought to you also by Superior Air Systems in the big orange vans trundling around Chattanooga and Hamilton County, 886-6602. That's Superior Air Systems for superior service. My name is David Tulis. I do thank you for giving us just a couple minutes of your time. We want to find out now about a matter that's a great peril to you. There's danger to you, my listener, because you like weapons. You like to have weapons around you. And in fact, you carry a weapon with you. I won't say where. I don't want to give it away, but you do carry a weapon with you. And there are legal perils that attach to that activity that you haven't thought about. So we're going to talk with an attorney, a practicing attorney in Nashville, who has a very strong gun interest. He is a weapons interest. He's a hunter, 54-year-old man named John Harris. He's married with 2 children, 21 and 27, neither of which are entering into the legal profession. And John was one of the 12 charter members of the Tennessee Firearms Association, and has been the executive director now for 2 decades. And the goal of that organization, which needs some local representation, some local support, I'd like to suggest, is to expand the rights of self-defense by way of weapons, by way of firearms, the fire stick. And John, we do welcome you here to the show. What is the main danger that my listener may not be aware about under the current statutes in our current legal system in Tennessee?
Well, the biggest danger, whether you're a permit holder or not in Tennessee, is that the laws concerning who can carry, when you can carry, where you can carry, and what you can carry have been patchwork now since the 1980s, to the point that, as a practical matter, they're not able to be easily comprehended or understood. And the risk is, if you violate any of those prohibitions, it's a criminal charge that can put you in jail, that can cause you to lose, business licenses or other licensure, and it's going to cost you money to deal with the criminal court system.
Well, why is the system rigged against my listener, the gun-loving, gun-toting, sometimes American man? What's the background in the law that makes that so dangerous?
The fundamental problem in Tennessee that your listener needs to really comprehend and embrace is that Tennessee, dating back at least until the middle part of the 19th century, or the 20th century, has fundamentally viewed the issue of ownership and possession of firearms as a crime. So we have a set of statutes that say presumptively it's a crime to carry, possess a firearm. And even having a gun in your home is a statutory defense to a criminal charge of possessing the gun. So, for example, Tennessee Code 3917-1307 makes it a crime, and Tennessee Code 3917-1308 says it's a defense to the crime that you're in your home, your premises, your place of business, that you have a carry permit. So the fundamental problem arises because Tennessee, instead of saying, as our Constitution does, that we, the citizens, have a right to possess, bear, and wear arms, our statutes are 180 degrees out of flip on that and make it a crime, and you have to prove your defense that you were justified in doing so under one of these numerous exceptions.
Okay, so in essence, there's a John Harris of the Tennessee Firearms Association. There's a blanket ban on the ownership of weapons, or the carrying of weapons, and then there are exceptions. And it's in those exceptions where the confusion arises. Well, what does the Tennessee Constitution say about weapons and arms, John?
Paraphrasing it, but the Tennessee Constitution has a clause that we refer to as Article 1, Section 26. And that's been amended 3 times, the most recent of which was in 1870, following the Civil War. And what the Tennessee Constitution says is the citizens of the state have a right to keep and bear arms, but the legislature shall have the power to regulate the wearing of arms with a view towards crime prevention. And it's a long phrase, and I submit that phrase was actually put in there after the Civil War so that the government could regulate who and when was wearing firearms. Then in 1871, the Tennessee Supreme Court, after that statute or that constitutional amendment was already being abused, came back and with emphasis said that the legislature could only regulate the wearing of arms in Tennessee if it had a well-defined crime prevention purpose. And that's really the last time our Tennessee Supreme Court has dealt with that issue. And I submit that what you see since 1871 is our General Assembly has largely ignored that constitutional limit that's imposed upon it and has not limited its regulations to those with a crime prevention purpose, but it's gone off wholesale, particularly in the last 40 or 50 years, enacting statutes that are based more on superstitions and political correctness than crime prevention purposes.
Well, the statute that's going to bite my listener in the rear end is the unlawful carrying or possession of a weapon statute. And it says a person commits an offense who carries with the intent to go armed a firearm or a club. And there was a trial December 22nd in Lawrenceburg, Tennessee, which I've covered at Nooganomics.com, in which the man defended his carrying a handgun in a concealed container in the cab of his pickup truck. But he was told by the officer who was testifying as to what the law meant that because he had a bullet in his gun, that proved intent. He intended to go armed, and he violated the statute because he had the gun somewhat in arm's reach, but there was a bullet in it. There were bullets in the cylinders. Therefore, he was prima facie, on the face of it, guilty of that, violating that law, and thus a criminal. How can that be? This statute. Talk about the statute, and does it not seem to go against the whole idea of wearing? The legislature has the authority to regulate the wearing of guns. Wearing is something. It's like wearing a watch or a pink bow tie, like I am today on YouTube. I'm wearing those things. If the bow tie is on the countertop where my computers are, that's not wearing it. How can the legislature control that?
You're exactly right. And part of the problem is in that situation. Yeah, I don't know when the charge occurred, but we have an amendment to the statutes that came up just in the last 2 years that specifically addresses part of that issue. But it's a very dangerous presumption that your listener needs to understand. For example, I have defended people, hunters. Actually, the last case I had was a turkey hunter. In Tennessee, the definition of a loaded firearm makes no sense. Because what Tennessee does is it actually does the inverse, and it defines an unloaded firearm as a firearm with no ammunition in the gun, in the chamber, in the magazine, in battery, and no ammunition anywhere in the vicinity of the gun. So to be unloaded, you really have to have substantial physical separation between the gun and the ammunition. So one of the last cases I handled in this particular area, It was turkey season here in the Middle Tennessee area, and I was representing a guy who had been charged by a Metro police officer, that's Davidson County, for carrying a loaded shotgun without a permit, because there's no permit for loaded shotguns at the time. And his situation was, the guy's driving a 4-door sedan. He's got a camo. It's turkey season. He's got a hunting license. The only weapon in the car was a 12-gauge camo shotgun, which was laying in the floorboard of the back seat with an open bolt, and there were turkey decoys sitting on the seat, and he had 3 shotgun shells beside him in the front passenger seat. So keep that in mind. Front passenger seat has the ammo. The gun is unloaded, open bolt, laying in the back floorboard. Because of the definition of in the vicinity and the way the courts have construed that, he was charged with illegally possessing a loaded shotgun. And as a practical matter, it was cheaper for him to surrender the gun, to forfeit the gun, to get the charges dismissed, than it was to fight over the constitutional issue of whether or not that was a legal restriction that was being imposed.
Well, my listener here is in that.
So
Go ahead. Well, my listener hears what you're saying.
He needs to really understand is the laws that our General Assembly has enacted and that this Republican supermajority has allowed to continue are so repressive that most people don't understand the risk, and they think that their handling of firearms, if it makes common sense, should make legal sense, and they don't in Tennessee.
Well, let me ask about this possession. Possession in the statute that I cited applies only to one who's a felon. The word you're charged with possession if you're a felon. That's the only occasion that possession would apply. And yet your defendant in the Hunter case was charged with possession of a shotgun, but he was not a felon, was he?
Well, no, in the statute you're looking at, which is probably 3917, 1307.
Yes.
Subpart A applies to everybody. So it's not a felon in possession. Subpart A applies to everybody. If you're carrying a firearm, the law presumes you're carrying with the intent to go armed. There's actually cases where people have been charged and they just bought the gun and was taking it home, or they're taking it to the gun range, they're taking it back to a gunsmith. There was no intent to go carrying the gun for self-defense. They had some other purpose, and they've been charged for that statutory violation. But it applies to everybody. Then we have heightened penalties, is what the rest of 1307 says. If you have a violent felony, a felony drug offense, or a nonviolent felony, there are different penalties for each of those classes, but they're just higher penalties,
Okay.
Under the possession statute, based upon their prior criminal status.
Well, if you have a carry permit, does that permit cover the wearing of the weapon only? What if my listener has a carry permit and he has let's say a Glock 9mm under his jacket, but he also has a loaded shotgun, let's say under the back seat of his minivan, let's just say. Well, is he liable for a charge, John Harris of the Tennessee Firearms Association?
Up until recently, he was. About 2 years ago, we were finally able to push through a statutory amendment that says if you have a Tennessee handgun carry permit, we're not a concealed weapon state, so we just call them handgun permits, that you can carry only a handgun on your person if you're out and about, walking the street, down the sidewalk, whatever. But the statute provided at that time that if you had a handgun carry permit, you could transport long arms, loaded or unloaded, in a vehicle that you legally possessed, as long as that vehicle wasn't an employer-provided car and the employer had a no weapons policy, or a government employer-provided car, regardless of the existence of a policy.
So that was the law that went into effect last year, John Harris. That was a
little before that.
Okay.
What went into effect, and it was a bill that Representative Micah Van Huss carried out of East Tennessee. That we passed a bill in 2014 that now says, and this is under 3917, 1307, subpart E, if you have it up. It says if you can legally possess a firearm, if you're old enough to legally possess it, and you do legally possess it, you can transport that firearm, whether it's a handgun, a rifle, a shotgun, a machine gun even, in a privately owned motor vehicle that you legally possess. And you don't have to have a permit for any of it. But you can only transport it in the vehicle. And because of all of our other statutory restrictions, that transport is pretty much limited to leaving your yard and driving on most public streets. You can't, with certainty, go into a parking lot, go into a public park, go almost anywhere other than on a public street.
What about if it's a borrowed car? Does that create a peril for my listener if he's doing that?
It doesn't really create a peril so long as you legally possess it, because the way the statute is written is in terms of legal possession and not ownership
of the vehicle, of the motor transportation.
Of the vehicle. And again, it retains that restriction that it doesn't apply to an employer provided car if there's a no weapons policy, or a government employment provided car, regardless of the policy.
All right. Under the new, we're talking with John Harris. This is David Tulis. John is from the Tennessee Firearms Association. He's a hunter and the executive director of this pro right to bear arms, pro gun, pro hunting organization in Nashville. Give my listener a nutshell bit of advice. Given the current law, then, which effectively lets you carry a loaded weapon of any kind in your car, where are the hazards? What can you do, and what should you be careful about getting caught doing if there's some fuzziness in the statute?
Well, if you're the permitless transport statute is what we're talking about, then what your listener needs to understand is they can't carry into public parks, for example, where if you had the permit, you could. You can't go onto school grounds parking lots. You can only go to school grounds parking lot if you have a permit. You couldn't go to any posted properties, regardless of whether you've got a permit or not. So you might have, for example, in large parts of this state, public roads that pass through public parks. Well, if you're relying on the permitless transport statute, you can't drive through that park because it's a crime for a non-permitted person to possess a firearm in a park unless it's hunting season and you get the hunting license and it's a hunting weapon.
What if you're going plinking with your son?
I'm sorry?
What if you're going plinking with your son and you're driving with let's say a couple of rifles and a couple of shotguns and a pistol? You don't have a carry permit. You're in your own car, but you're driving, let's say, an hour out into the countryside to visit a family friend. The hazards there, and let's say you're passing through a state park. All right, the hazards there are the state park. Is that what you're saying, John? If you are stopped,
if you travel through a state, federal, or local park and you are not a permit holder, you run the risk of being charged for possessing a firearm in the park. If you're a permit holder, you could do it, and there's no charge that could be brought against you. That's one reason that I think most people don't understand. And your listeners need to understand that our current statutory scheme has so many buts, ifs, and conditions in it that it's almost impossible to say with certainty, unless you study this stuff regularly, where you can and can't go in possession of a firearm, whether it's loaded or unloaded.
Is there any way that a criminal defendant who attacking the constitutionality of the intent to go armed statute could overturn that? And if he did, what would the legislature, seeing its statute is about to fall on appeal, could rewrite the whole thing? Is that possible, or is this somehow so old and so familiar that the high court will just somehow find a way to let it stand?
Yeah, I think that particular language has been on the books for so long that it's unlikely that our current Supreme Court would overturn it. What we have tried to do is to get the legislature to make a minor adjustment to get rid of the phrase "with intent to go armed" and to substitute that it's a crime to carry a firearm with criminal intent or in the facilitation of another crime.
That would be much better, because intent to go armed means that if you have a bullet in the gun or near the gun, that's intent. So criminal intent, I think, it really should be what's in view, John Harrison. You're suggesting that criminal intent. Okay.
It would be much better, because intent to go armed draws no distinction between offensive and defensive purpose. Whereas if you said with criminal intent, it would only be with offensive purpose.
Right. So a man who's
that's a better step, definitely.
This is David Tulis. We're talking with John Harris of the Tennessee Firearms Association. We're going to talk next about other things that are kind of advice for you, you, my listener, the man who matters. You're also the man who's going to want to have his indoor ducts cleaned by Ducts Indoor Professionals. Call Ducts, formerly known as Duct Busters, taking the mold and mildew and the junk out of your long-neglected duct work. The number is 876-9907. That's 876-9907. And that's Ducts, the Indoor Professionals. This is David Tulis. We are talking with John Harris of the Tennessee Firearms Association, a great organization. Learn a little bit more about that. But first, I've got some things I want you to hear. These are important messages. Hang on.
Live from Chattanooga, Tennessee, it's Nooganomics with David Tulis.
You can save up to $10,000 by going to Don Ledford General Motors, Don Ledford General Motors in Cleveland, and buy a testosteronal muscle truck for your heavy lifting needs and your work and your plant at Don Ledford, and save $10,000. He's also offering a little tickler at the top of your purchase of his truck. $1,000 gift card to help you pay for Santa. That's only at Don Ledford General Motors in Cleveland. And do go there very, very soon. The time is running out. You've got until January the 3rd or the 4th to make contact, make the engine roar at Don Ledford General Motors. Also, Rick Davis wants to thank you, his customer at Rick Davis Gold and Diamonds. Wants to thank you for a prosperous year that you gave him last year, and patronizing his shop. Remember, he's the man who gives you cash for your bracelets, your diamonds, your jewelry, and with the ubiquitous billboard, he's always there waiting, and he is always in the shop waiting to serve you. That's Rick Davis Gold and Diamonds. And my name is David Tulis. I do thank you for giving us a couple of minutes of your time. We're talking about traps today. There are traps in the law that affect you, my listener, the man who likes to think he's a free man. You're the armed citizen of the kind who fought off the British. But Tennessee is a devilish place in many ways. Its laws are turned against you. The whole system of statute in Tennessee seems to be out of keeping with the spirit of the Constitutional Bill of Rights that says that you essentially have free use of weapons as you will, except for the legislature having the authority to regulate the wearing of them. So wearing has been transmogrified by the good people in Nashville. And John Harris of the Tennessee Firearms Association is here to explain where the traps are. John Harris, tell my listener, the man, let's say, who does not have a concealed carry permit from the Department of Safety. He doesn't have a permit, but he likes to carry guns around with him, sometimes on his person, even in the form of a revolver. But he has things about him on his mode of transport. What are the dangers that my listener faces, John Harris?
Well, the listener needs to understand that under Tennessee law, a civilian who does not have a handgun permit cannot carry a firearm in public, frankly, loaded or even unloaded. There's a Court of Appeals decision that says, if you pulled a gun and pointed it at someone aggressively, that they're not going to know if the gun's loaded or unloaded. So either way, it constitutes an assault. It wouldn't be a defense that it was an unloaded gun. So the courts have taken the position that even the transport of a firearm, unless it looks innocuous, it's in a range bag, it's with your hunting gear, that it requires a permit in Tennessee. Now, we have this law now on the books that allows the non-permitted person to transport firearms in a personal vehicle as long as they legally possess both the vehicle and the firearm. Where I see that creating problems for permit holders and non-permit holders is if they, exhibit the gun to anybody while they're driving around with it. So if they pick it up, raise it up, show some other driver that they've got one. I've got a case right now where a guy's been charged with assault with a deadly weapon because he was in a road rage incident. He was concerned that the other guy was acting too aggressively, and he picked up his handgun to show him that he had one. I didn't point it at him, just showed it to him. But he's been the one arrested and charged for assault with a deadly weapon.
Now, assault means simply threatening someone, right? Battery is when someone is hit by a threat. Assault is the appearance of a threat or the intention of delivering a threat of some kind, and that's what that man is charged with. Assault.
Right. That's the common law distinction.
Okay.
The problem for the non-permit holder, as we talked in the first segment, is Tennessee law just fundamentally ignores our Constitution and the federal Constitution, and approaches the issue of civilian possession of firearms as presumptively criminal. And you have to be able to point to some statutory exemption or exception or defense in the event you're charged. So, for example, we have statutes that say it's a defense to a charge of illegally possessing a firearm that you're at your home or at your business or at your premises. Say you own a farm, but it's not where you live. All of those are statutory defenses. But the question is, why should they be a defense if we have, in fact, a right as citizens to keep and bear arms? Why is it that our statutes don't say that it's just a crime to use or misuse a firearm with criminal intent or to harm someone else? Why do we go much further than that and presumptively ban civilian ownership unless it's done in accordance with, a number of now statutory exceptions?
Let me ask you about flare guns in vehicles. A flare gun is not a firearm, as far as I understand. Do you have any insight on that? Is having a flare gun a way of avoiding a possible charge and yet having a device which discharges a projectile?
No, it probably fits the definition under Tennessee law, because Tennessee law's definition of a firearm is distinctly different than federal law. And so Tennessee merely says if it discharges a projectile with a chemical reaction, then it's a firearm. So, for example, black powder weapons under federal law are not firearms. Black powder weapons under certain Tennessee statutes are firearms.
What are other traps?
True for flare gun.
What are other traps that my non-permit holding listener faces in possessing, using, transporting weapons, either for plinking outings, either for hunting, or self-defense? What are some things that he needs to know that are very important for his personal protection against the state?
The advice I give typically is, if you don't have a carry permit in Tennessee, you really shouldn't travel with a firearm unless it's stored in your vehicle in an area where it's not immediately accessible to you, and generally where the ammunition is separate, because even though our statute, it's relatively new, allows someone without a permit to transport, as we've talked earlier, the problem I see, like this situation we talked over in Lawrenceburg, is there's a lot of police officers that don't understand it that way. They've not been taught that the law lets them do that. So what happens is people who are in compliance with the law are still getting arrested and charged in court costs and have to go hire attorneys. And those are traps we shouldn't see, but they're traps that exist because our statutes are confusing enough that they're not even being accurately taught to law enforcement.
Well, what would be an example of a misapplication of that law by, let's say, a state trooper upon a motorist with a gun? How is it that he misconstrues his authority to enforce a law against an innocent person? Give me an example of how that would work.
I have, unfortunately, I've seen that happen repeatedly over the last 2 decades, that officers who in many instances think they're following the law just have such a difficult time comprehending what the law allows or disallows that they err on the side of making the arrest, and they let the DA or the magistrate tell them they have overstepped. I don't know if it's pressure on the officers or just literally officers who are inadequately trained as to what the law currently permits or prohibits.
So let's say
the only solution to that is better training for the officers, because you're not going to argue your way out of that as a civilian.
My listener who carries, let's say he carries an SKS with a 10-round stripper clip in it. He can. Is it a defense for him to say, well, I have my gun, but notice I had some targets with me, and I had some cans, and I had that gun in my car because on the coming weekend I was going to go shooting with my son, and so he kind of has a demonstration of going on a lawful innocent outing with a weapon. Is that the kind of thing he still needs to do in light of our new statute? The new statute says you can have a loaded gun in your car.
Right.
Does he have to have these kind of ruses?
Doesn't even require that at this point. The problem is the officers don't consistently construe the statute that way. And so when you're out there on the road or the side of the road with an officer, it really doesn't matter what you think the law is or not. He's the one with the arrest power. And the only thing that matters at that point is what he thinks the law is.
Well, do you have some kind of legislation that you, John Harris, at the Tennessee Firearms Association, are proposing? Is there some way of remedying the words? We are, in fact, talking about words that are written in concrete in the statute. Are you proposing changing these words to bring relief to my listener?
Yes, we've got a bill that we actually introduced last year, and it's meeting a lot of resistance from Governor Haslam's administration. But Senator Beavers, who's in the Mount Juliet area, is the Senate sponsor, and she's carried a lot of these kind of bills. But we've introduced legislation to adopt full constitutional carry in Tennessee with an optional permit for reciprocity purposes. If that legislation goes through, it's about a 17-page bill, it will invert this presumption that civilian possession is a crime. And the result would be that we would punish people that possess and use firearms with criminal intent, but the average civilian would no longer be operating under the presumption that mere possession, mere self-defense transport is in any way criminal chargeable conduct. And that kind of legislation, I think, is what it's going to take. The other thing that we're doing is, based in part upon what happened in Chattanooga, is we are running a set of bills to eliminate gun-free zones as much as possible in Tennessee. And so the two of those things being pushed through, if we're successful, would clarify the law, simplify the law, and I think reconcile the law with what most conservatives think the law already is.
And most conservatives think the law is what, John Harris? What do we people like me think it is?
They have a right to carry a gun for self-defense.
Okay.
And that they don't need a permit, and they shouldn't pay a fee, the equivalent of a poll tax, to get the government's permission to carry a gun for self-defense, or to go to the range, or to have one at their home. Most conservatives don't think, because of the Second Amendment, that is a legitimate area of governmental, either state or federal or local regulation.
Now, you're appealing to a Republican administration. Are the houses of the General Assembly, they're overseen by Republicans, right, John?
Oh, absolutely. We've got a supermajority in the General Assembly, plus we've got a Republican governor.
Well, what is it in the Republican way of thinking that makes it as a party hostile to this sort of liberty assertion in your 17-page bill? What's wrong with it?
First off, with Haslam, if your listener would go to TennesseeFirearms.com/Haslam, they'll see a video of where he promised us on the campaign trail that he would sign constitutional carry. He made that promise in 2010. It's 2016, and he has actively fought the passage of constitutional carry, or even the removal of restrictions, the entire time he's been in the legislature. We've got a governor that made a promise and he's broken it. Surprise there. Then in the General Assembly, we have a supermajority, and what we have seen with it is that the conservative branch of the Republicans, and they're in the minority in the General Assembly, are willing to pass constitutional carry and the elimination of gun-free zones. The problem is most of our leadership is what conservatives pejoratively refer to as rhinos. They say one thing but do another. So, for example, I'll give you a perfect example that's on our website again. We've got two legislators that Speaker Harwell appointed in the House that oversaw a subcommittee where we were running permitless open carry. Again, Micah Van Huss. These two legislators, Jim Coley from Bartlett, Tennessee, and John Lundberg from Northeast Tennessee, voice voted to kill these pro-gun bills that would have eliminated the permitting requirement for open carry. And then, 2 days after they voted no to kill the bill, we noticed that their voting records, their official state record of their vote, had been changed from no to present not voting. And so we've got a video of Jim Coley on our website saying, yes, I voted no, and yes, I changed my vote officially to present not voting, and I did it, and I'm paraphrasing, because I didn't want my constituents to know I was voting against the gun bill. Now, the problem we have in Tennessee is we've got Republican legislators that act like that don't even want to be honest with their constituents about where they are on the Second Amendment.
Well, we're talking with John Harris, and my listener wants to know, John, what is it that the Tennessee Firearms Association does? Tell us just briefly why he should support your organization as a kind of lobby, as a kind of think tank for the right to bear arms. What is it that you're doing? Why should he care about the Tennessee Firearms Association, based in Nashville, with its 12 charter members, of which you are one of them, and you're also the executive director and have been for 20 years? Why should he care about what you're doing? Why does it matter that we have
we had 12
Tennessee
charter
Firearms
members, but
Association?
we've got tens of thousands of members now across the state.
Okay. Who are these members?
For 20 years.
Who are these members, and what do they do? Go ahead.
I'm sorry?
Go ahead. I was asking, who are these members, and what do they do, and what do you do for them?
Okay. Well, I serve, I'm a full-time practicing attorney, and I serve as a volunteer, in a volunteer capacity, as the organization's executive director, and I've done that for 2 decades. My office is literally across the street from the General Assembly, so I'm very accessible to those people. And what the TFA was formed to do, because we realized immediately in '94, when the first shall issue law was passed, that the NRA's recommendation for how to pass carry permit laws in Tennessee was poorly reasoned, because it didn't address the historical statutory scheme in Tennessee, nor did it address a large number of cases which had construed those statutes. So we've worked for 2 decades to try to bring expertise to the General Assembly as a grassroots organization on what the problems are with Tennessee's Second Amendment legislation and how do we fix them. And the reason that we have thrived as an organization and have grown is because we have demonstrated expertise. We have a number of legislators that are members of our organization, that are life members of our organization, and that ask us to help them draft bills such as this constitutional carry legislation that we're backing. And the benefit to your listener to join and support TFA, unlike some organizations, we don't take your membership money and then spend it and send you a hat and a magazine and a logoed pocket knife. We don't waste the money that way. Whatever funds we raise through membership support, we use to, run the website, print literature, help, get our speakers out in networks to talk to Reagan Day dinners and local GOP groups that ask us to send speakers to them. We use the money specifically to advance the Second Amendment in Tennessee, and at the same time to try to distribute as much free information as we can to the voters of Tennessee and to the gun owners of Tennessee, so they accurately have an appreciation for what the law is and what the risks are on them.
So the amount that you ask for a membership is very small sum. How much is that, John? And where does my listener...
$35 a year.
How much?
$35 a year.
$35 a year.
They can, we make it easy. They can go to our website, TennesseeFirearms.com, and join right online. In addition, if they're interested but they're not sure they want to put some money in yet, they can sign up for our newsletter. It's an email blast. And they don't even have to be a member to do that. They can just get it for free. Because our theory has always been, we want you to know who we are and what we do. And if you agree, support us. You know, we're not going to make you pay before we tell you, you know, what the secret handshake is.
This is David Tulis, and we want to recommend that you think about getting dinner tonight on the way home. Make an exception. Go to Armando's in Hickson, where Anthony Johnson makes the best hamburgers in town, the best cheeseburgers, all loaded, and great fries. His restaurant is Armando's in Hickson, right across the way from, on the same side of the street as the Chester Frost Park entrance. He's right there at the new Thrasher Light going up on Hickson Pike. He's got catfish, BLTs, pecan pie, hot tea, cold tea, steaming coffee, and all the great American fare that we know and love. Go to Armando's. Well, John Harris, thanks for joining my list for me here at AM 1240 Hot News Talk Radio.
Thank you for inviting me this morning, and I look forward to coming back.
John Harris is the executive director of the Tennessee Firearms Association at TennesseeFirearms.com. That's TennesseeFirearms.com. And this is David Tulis. I recommend you join now. Go there and put your $35 in the hopper, become a member. There's a lot of work to be done defending the free man and clearing up a messy, ugly, bitter, angry statutory scheme here in Tennessee that's against your rights. It's against your rights, and it makes you a crook.